everyone. I'm Victoria Lozano, attorney and founder at Planford Legal. I wanted to take a moment to talk about probate court. So, probate court is where someone goes with their deceased person's will or their death certificate if there's no will or any type of estate plan. So the purpose of probate court is to assign the deceased person's assets. If a will is in place, then the judge will look to the validity of the will, and to the extent that it can, the judge will make sure that the assets adhere to that will. If the person does not have any estate plan, no will, nothing, there are default laws that the judge will adhere to. So, what are some of those default laws? Typically, to a spouse, to the kids. If you don't have a spouse, then to the kids. If you don't have a spouse or kids, then to parents. If no parents, then siblings. So there's like this whole family tree that it like branches out to. So when do people get access to these assets through the probate court? Well, they have to wait because probate court has to allow for time for creditors to contest, meaning you have to allow time for creditors to make a claim on what the deceased may. Probate court in Illinois is a little easier than other states. For example, there is a truncated process for people who pass away with assets valued at under $100,000. What we typically see are people who pass away with property, and typically that property is valued over $100K. So, do you need an attorney to go through probate court? In famous attorney words, it depends. Sometimes you do, sometimes you don't. What I have come to the understanding is if you can afford to give yourself the care to grieve, then choose an attorney hands down. However, even if you cannot afford it, typically the estate can, because this is under the assumption that it's over $100K. So if you are someone whose family member or person passed away and their assets are valued under $100K, then you should be able to do it on your own. It may not be fun. It may be really scary and sad, but typically in that situation, probably you may not have the money. The family member who died doesn't have the money. So it may be better to do it on your own. If there's property involved, or there's multiple creditors, or that the family situation may be sticky, and granted, you may think everything's okay, but grief does really weird things to people. So if those situations arise, then I would heavily suggest relying on an attorney. To give you some insight into myself, my mother died in 2020 in South Carolina. She died what's called intestate. She had no estate plan. And in South Carolina, you can have an attorney or not. So I tried to do it on my own. And what I can tell you about that experience is it was scary, exhausting, frustrating. It required a lot of my time. And my siblings were anxious and told me how anxious they were through the entirety. And it also took 2 years. So I tried calling to different attorneys. Many of them I was unable to get in contact with. So what I'm learning and what I learned from that process is I would like to be the attorney that I never had. So if you find yourself in a situation where your loved one has passed, typically by law, you're supposed to file the will within 30 days of the deceased's death date, and you are to petition to the court to open probate. If it's over the 30 days, that's okay. We can work through it. But typically, if it's over the 30 days, it's probably because you're already feeling overwhelmed by this whole process, and having a representative, an attorney doing this work for you is really an act of self-care. So I would say for sure hire an attorney. The probate process takes time. It's very public. Whenever you go through probate, people because it's an actual case. So there's a motion to open, there's different motions to provide information, and all the while that can be found by the public. So if there are family members or creditors who are looking to see what assets are available, it makes it very easy for these assets to be seen, which can cause some problems and situations that you may not be aware of, which is also why I think it's important to have an attorney with you. Probate is a process. It is a, a process that requires patience, and it is a process in which, when going through it, it's important to note that even though there may be a will indicating certain wishes, it is inevitably up to the judge to decide. So if there was a wish in the will indicating that a certain family member will get X amount of money, but after creditors have come through, after debts have been paid, if that money is not there, then the money cannot be given. Or if a family member who was a caretaker decides to challenge and say, well, I was promised this, then the judge may feel as if that promise should be fulfilled, regardless of what the will says. So it takes patience. It takes kind of giving up a little of control and expectation and reliance on a document. There are alternative estate planning strategies like trusts, land trust, transfer on death instruments, beneficiaries that can work around probate and can be kind of like contracted out of the law. So that's a route that some people can take. Some people, it's just easier to just go through probate. It really just depends on your financial situation, your credit situation, your asset situation. So if anything, I would say it's important to talk to an attorney about what could happen, about if you had nothing planned, if you had something planned, if you had the most extensive protection planned, that we can get a good idea of where you want to go and how you want to choose. So thanks for listening, and I'll be giving more little education. Please know, as a disclaimer, I am not giving any type of legal advice. If I misspeak, I would love to hear. Please let me know in the comments down below. In no way am I advocating for you to or telling you to do things on your own or not do anything on your own. I am just simply sharing my experience and encouraging you to dig a little deeper too. Thanks.